A Land Optics presentation. The Village of Grand Beach, a case study on short-term rentals. The Village of Grand Beach is a chartered municipality within the confines of New Buffalo Township, Michigan. It is a lakefront residential community consisting of approximately 450 housing units. The village zoning ordinance contains 3 separate residential districts, categorized as high, medium, and low density, in addition to an environmental overlay district. The 2024 Village Master Plan maintains that Grand Beach is a single-family residential community, home to families in the area district school and many retirees. Its idyllic residential characterizations are the basis for its zoning ordinance. The Master Plan's vision statement reads, Grand Beach strives to be a premier lakefront community that embraces relaxation, recreation, community activity, natural beauty, and safety, which promotes family and friends to come together for generations. Grand Beach has no zoning provisions for independent commercial businesses. It has strict home occupation guidelines, and the municipality runs the village golf course. Vacation rentals are a historical cornerstone of the village of Grand Beach. However, traditional vacation lodging over time has moved from summertime cottages and bungalows to the direct commercialized residential home sharing that has become so prevalent nationwide since 2010. Nowhere has suffered the per capita impact of this residential housing transition more so than the coastal municipalities of the state of Michigan, and those effects are now well documented here in Harbor Country. Short-term rentals' impact on the Harbor Country region of southwest Michigan has been character-changing. The subprime mortgage crisis of 2008 put home values in this area at an all-time low for many of the following years. Coincidentally, the economic conditions nationwide spurred the sharing economy, creating an industry of sharing services of all types, most notably home sharing. Home sharing, or vacation rentals, from a residency standpoint, quickly switched from empty nesters sharing extra bedrooms to residential homes being purchased for the sole purpose of permanent vacation lodging. Berrien County Strategic Leadership Council is a collaboration of individuals from the public, private, and nonprofit sectors who seek to collectively identify countywide challenges. In early 2024, it released its second countywide study on housing, dubbed Housing Diagnostic Tool 2.0. A comprehensive set of data aggregated by subregion that gives us conclusive findings on the county's housing issues and addresses potential solutions. One of the key supply issues identified as a major problem is, quote, the prevalence of vacation homes, second homes, and short-term rentals is greatly reducing the overall housing supply, especially in coastal communities. While this shouldn't be a great surprise to anyone, the most important metric for the purpose of this discussion is the data on residential use density. Our region, known as the Southwest region, not only has the oldest median age in the county at 50, but we also have the lowest residential use at 2.2 residents per home. Residential use, or RU, is a metric used in planning to determine the human impact that is created by the density of areas in which we live. Anyone buying a home in Grand Beach, New Buffalo, or Three Oaks is doing so under the assumption that despite the recreational and summer vacation aspects of the area, residential neighborhoods are filled with middle-aged people with children or retirees. Short-term rental activity is a complete distortion of that. Grand Beach's short-term rental permit list contains 46 homes, with an average occupancy of 12. That is 5.5 times the standard residential use in Grand Beach. Rentals with a maximum occupancy of 16 are 7.25 times the standard residential use. Short-term rentals in Grand Beach create an impact of increased traffic, vehicles, noise, and human beings in local neighborhoods that is 5.5 to 7.25 times greater than what is considered normal home use for the area. That is strictly based on their occupancy limit and before any regulatory violations based on local ordinances. Directly adjacent rentals only double the impact to surrounding residential homes. Using the current 7 permitted rentals in the Gulfmore Estates neighborhood as an example, the combined occupancy of those 7 rental homes is 98 people. That number of additional residents and the proximity of rental homes being within 500 feet of each other creates a direct impact to every single resident of Fairway Drive and Putter's Lane. This residential use metric can be used by homeowners to demonstrate an irreconcilable conflict with a retirement lifestyle and an immediate safety consideration for residents with small children. 2 cases from United States Supreme Court history still maintain direct relevance today and are mentioned continuously in modern case law regarding short-term rental use. Munn v. Illinois, 1877. Quote, "A landowner cannot use their property in a manner that unreasonably interferes with another landowner's comfortable use and enjoyment of their property." This case remains a cornerstone of constitutional law due to its lasting impact on the balance between private property rights and the government's power to regulate businesses in the public interest. Village of Euclid v. Ambler Realty Company, 1926. This Ohio case established what we call today Euclidean zoning. It upheld local government rights for exclusionary zoning and made clear why special land uses are important in terms of nuisance law. Quote, "Something may be the right thing but simply in the wrong place, such as a pig in a parlor instead of a barnyard." An appropriate quote from a bygone era. Both these cases are the basis for today's legal framework for nuisance law. Zoning has an obligation to prevent harm by preventing potential nuisances proactively, by designating certain areas for specific types of use or development. Short-term rentals are commercial businesses. This is well established by Michigan case law. Aldrich v. Sugar Spring Property Owners, State of Michigan Court of Appeals, 2023. Quote, "We conclude that under the definitions set forth in Terrian, the act of renting property to another for short-term use is a commercial use, even if that activity is residential in nature." Terrian is a reference to Terrian v. Zwitt, State of Michigan Supreme Court, 2002. This case ruled the operation of a for-profit business, even within a residential setting, constitutes a commercial or business use of property, violating any covenants that prohibit such uses. Residents in Grand Beach, aggrieved by short-term rental use in their neighborhoods, have a strong argument that the commerciality of short-term rentals and the perpetual nuisance created by their occupancy allowance is in direct conflict with both the Grand Beach zoning ordinance and the clear intent of the village's master plan. This should be reconciled. Harbor Country municipalities have struggled with short-term rental proliferation in residential areas for many years now. Some don't allow it at all. Others have taken strong steps to regulate it, including permit caps or residential area bans. In southern Berrien County, 4 municipalities still struggle with the rental versus resident dynamic. They are New Buffalo Township, Chickaming Township, and the villages of Michiana and Grand Beach. New Buffalo Township and Chickaming Township each have an estimated 400 rental permits. Both townships' boundaries cover over 20 square miles, and both have a very small police presence or have inadequate code enforcement personnel to manage the number of rental homes. Grand Beach and Michiana are much smaller, but both suffer additionally from the density of rentals in specific areas. Residents of Grand Beach have made many previous presentations to the Village Council pleading for relief over nuisance and density issues. Despite excellent analysis and over 50 resident letters of support, an unprecedented number in village history, calling for reforming the current ordinance and alerting officials to properties commercially advertising occupancies in violation of the village ordinance, the Village Council seems unmoved. The Village Planning Commission does have an edited version of the latest presentation on the village website, acknowledging these problems exist. The Village of Grand Beach's short-term rental ordinance regulates short-term rental activities as a police power, and the Village of Grand Beach's zoning ordinance allows short-term rentals as a land use by an administrative special use permit. Each of the three districts specifies single-family homes as the principal permitted use. Short-term rentals are designated in the zoning ordinance as a conditional special land use. Short-term rental permits are awarded administratively through what the zoning ordinance describes as a special use permit, which is issued to a person or persons intending to undertake the operation of an activity described in the zoning ordinance. Short-term rentals in the Village of Grand Beach are a special land use. The Michigan Zoning Enabling Act is the state statute that sets forth the procedures in which zoning may be applied. Section 125.3502 covers special land uses and is quite clear that upon receipt of any application for a special land use, that any owner of real property within 300 feet be notified in writing of the potential special land use, and a public hearing be held before a discretionary decision is made on the special land use request. These decisions would be made by the Village Planning Commission, who would then make the recommendation to the Village Council for approval. As this has not occurred, aggrieved residents have every right to make the argument that their basic property rights, per the state statute, have been violated. Despite the overwhelming expression of resident views that the number of police complaints is not the correct metric to be used, village leadership continues to rely on police complaints as the key metric to substantiate policy change. Most people simply won't call the police on nuisance complaints if they must leave their name. Anonymous tip lines are much more effective for violation reporting. The Council's past dismissals of valid information brought forth by residents in letters, public comments, and presentations have only further discouraged police complaints for what is seen as a perpetual nuisance by the affected residents. Substantiated police complaints are a metric, but they are not the sole metric, and in this case, the wrong metric to use in crafting policy. The reality is that violations are really an effect of a policy that is not working, and there are much larger issues that need to be addressed. The Village Planning Commission formed a short-term rental committee to make recommendations in an attempt to deal with nuisance issues, but it's very unlikely and so far unwilling to discuss the core issues, nor does it have the capacity to discuss these key issues. A. How to fix the density of permitted rentals in a manner that works for the various neighborhoods. What works in the high-density area of Old Grand Beach does not necessarily work in the medium-density area of Gulfmore Estates. B. The commerciality of short-term rentals in congruity with both the zoning ordinance and the master plan, and the conflict with the master deed restrictions in the Eiffel Tower neighborhood that prohibit such uses. C. The conflicts between the village short-term rental ordinance and the village's zoning ordinance. The contradictions in the zoning ordinance definitions and using a special use permit to bypass the requirements of the Michigan Zoning Enabling Act, Section 502, on special land uses. D. How 16 people is not considered a hotel, but 17 people is considered a hotel. Evidence has been presented to the Council that certain permit holders have advertised occupancies of many more. Hotels are not allowed in the Village of Grand Beach per its zoning ordinance. E. How state-mandated group daycare homes in the village zoning ordinance have a 1,500-foot buffer between locations, but short-term rentals do not, while the transient nature of the two as short-term lodging are identical. These are not challenges for an ad hoc committee. They are best left to the village's planning commission with the advice of professional consultants. It would be a prudent recommendation that the Village of Grand Beach pass by resolution a 6-month moratorium on the granting of new short-term rental permits while it addresses these 5 major points. These should come through the recommendation of the Planning Commission for vote by the Village Council. Personal interviews and documentation supplied by residents suggest that the following be implemented in any future changes. That all future permits go through the proper special use process with the appropriate public hearings. That each residential district's short-term rental allowance be determined by lot size. Considerations for density and occupancy limits be based on the practical use of that area. While Old Grand Beach has traditionally had and could maintain many small rentals at lower occupancy, Gulfmore Estates is oversaturated with large commercial properties, and the residents are mainly retirees that need relief. Eiffel Tower, due to its property's deed restrictions, should not have short-term rentals at all. New developments in the village could be zoned as rental overlays that would allow commercial development and not impact existing residential neighborhoods. A maximum occupancy should be agreed to and strongly enforced. This should be much lower than 16 persons. A yearly permit cap at 10% of total residency. Yearly permits should not be automatically renewed, but reconsidered based on a lottery system to offset density issues and potential complaints. On a go-forward basis, non-resident, large commercial properties should be eliminated from the Village of Grand Beach. Existing commercial properties should be grandfathered, but over time brought into compliance with other reform initiatives. A code enforcement officer should be hired directly by the village or outsourced to provide consistent and rigorous code enforcement on all code issues, not just short-term rentals. The burden of code enforcement should not fall solely on the village police chief. The cost for this position should be borne by the homeowners that rent. And finally, the Planning Commission must also answer the question, is it time for a new zoning ordinance in the Village of Grand Beach? Thank you for your attention.